There is a Social Security rule that only turns on if a marriage lasted 10 years, not 9 years and 11 months. 10. And here is the part that stops people cold when they hear it. If you qualify under that rule, the money does not come out of your former spouse's check. Not $1. Their check stays exactly the same. Their current husband or wife keeps everything they were getting, and Social Security does not pick up the phone to tell them you applied. So today, we're going to walk through who this rule actually covers, what it is worth in real dollars, and the 2 dates that decide everything. Welcome in. I'm Ray. On this channel, we slow down the scary rules and the confusing ones. We read them the way the agency actually writes them, and we decide with a calm head instead of a racing one. No panic, no politics, just the rule and what it means for the money that shows up in your account. Let me start with the feeling, because for a lot of people, this one comes with a knot in the stomach. If your marriage ended, the last thing you want is to feel like you are asking your former spouse for anything. I hear this in comments all the time. People say, "I would rather do without than go back and ask him." Or, "We settled everything years ago. That chapter is closed. I am not reopening it." That instinct makes complete sense. And I want to take the sting out of it right now, because the instinct is built on something that is simply not true. You would not be asking your former spouse for anything. You would not be taking anything from them. This benefit is not paid out of their check, and it is not something they get to approve or deny. It is a benefit that Congress attached to a work record, and if you meet the conditions in the law, it is yours to claim in your own right. Your former spouse does not sign a form. They do not get a letter. They do not get a vote. So let us go through the conditions, one at a time, in plain language. Condition number 1 is the 10-year rule. The marriage has to have lasted at least 10 years before the divorce became final. And I want to be precise about how that gets counted, because this is where people lose the benefit by inches. The clock runs from the date on your marriage certificate to the date a judge signed the final divorce decree. It does not stop on the day you separated. It does not stop on the day one of you moved out or the day you filed the paperwork. If you were married in June of one year and the decree was signed in April 10 years later, you are short, even if the two of you had been living apart for years by then. That sounds harsh, and honestly, it is a hard line, but it cuts the other way too. And this is the part more people should hear. If your marriage was long and messy and the divorce dragged on for 2 years in court, all of that waiting counted. Plenty of people assume they do not qualify when the actual math on the 2 dates says they do. Before you decide you are out, go find the 2 pieces of paper and count. Condition number 2, you have to be unmarried now, not your former spouse, you. If you remarried, the benefit on your former spouse's record stops being available to you while that marriage is in place. And if that later marriage ends, whether by divorce or by death, the door can open again on the earlier record. So the question the agency is asking is not what your history looks like. It is what your status is today. Condition number 3, you have to be at least 62. Same age floor as your own retirement benefit. We will talk about why claiming at 62 costs you here just like it costs you everywhere else in Social Security. Condition number 4 is the one almost nobody knows, and it is the reason this rule is genuinely more generous for divorced people than for married ones. If you are still married and you want a spousal benefit, you have to wait for your spouse to file for their own benefit first. You are stuck on their timeline. But if you are divorced, there is a separate door. If your former spouse is old enough to qualify but has not filed yet, you can still claim on their record as long as the 2 of you have been divorced for at least 2 continuous years. They can be 66 and still working and not thinking about Social Security at all. You do not have to wait for them, and you do not have to talk to them about it. Now the dollars. How much are we actually talking about? The ceiling is 50% of your former spouse's benefit at their full retirement age. That is the number the agency calls the primary insurance amount, and I am going to keep calling it their full retirement age benefit so it stays in plain English. 50% is the most this can ever be. It is not 50% of what they are getting if they took it early. It is not 50% of what they get at 70 after delaying. It is 50% of the middle number, the one that belongs to their full retirement age. And to get the whole 50%, you have to wait until your own full retirement age to claim. Claim earlier and it shrinks permanently. At 62, this benefit lands at roughly 32.5% of their full retirement age amount instead of 50. I say roughly because your exact reduction depends on how many months early you are, which depends on your birth year. The formula the agency uses reduces the benefit by a fraction of a percent for every single month you claim ahead of your full retirement age. Let me put real numbers on that. And I want to be clear, these are illustration numbers, not a promise about your situation. Say your former spouse's benefit at their full retirement age is $2,400. Half of that is $1,200. If you wait until your own full retirement age, $1,200 is the number in play. If you claim at 62 instead, roughly 32.5% of $2,400 is about $780. That is a difference of more than $400 a month, and it does not go back up when you hit your full retirement age later. It stays reduced for as long as you receive it. Now here is the piece that trips up almost everyone, so stay with me. You do not get your benefit plus that benefit. They do not stack. Social Security pays your own retirement benefit first, and then, if the spousal amount you qualify for is higher, it pays the difference on top. You end up at the higher of the two, not the sum. Same example. Suppose your own retirement benefit at your full retirement age is $900, and half of your former spouse's is $1,200. You do not get $2,100. You get your $900 plus a $300 top-up, and you land at $1,200. If your own benefit is already higher than half of theirs, this whole conversation is interesting, but not useful to you, because you were always going to be paid on your own record. Let me run a second set of numbers, because the gap between claiming early and claiming on time is the single biggest decision in this whole video. Say your former spouse's full retirement age benefit is $3,000, and you have almost no work record of your own. At your full retirement age, half of $3,000 is $1,500 a month. At 62, roughly 32.5% of $3,000 is about $975. Call it $525 a month between the two choices. Over 10 years of payments, that gap is real money, and unlike a lot of retirement decisions, this one is locked the moment you file. Now, I am not going to tell you that waiting is automatically right. Waiting only works if you can pay the bills in the meantime, and some people genuinely cannot. If your choice is claiming early or running down the last of your savings at 63, claiming early might be the sane answer. But make it a choice, not an accident. The worst version of this is filing at 62 because you assume the number would climb back up on its own later. It will not, which leads to a practical point. Go pull up your own estimate first. If your own number is comfortably above half of what your former spouse would get, you can stop worrying about their record entirely. If it is below, this rule is worth real money to you every month for the rest of your life. Let me deal with the three fears directly, because I think they stop more people than the rules do. Fear 1. I will be taking money out of their pocket. No. Benefits paid to a divorced spouse do not reduce what the worker receives. They do not reduce what the worker's current husband or wife receives. They do not reduce what the worker's children receive. There is a cap on how much a family can draw from one work record, and this is one of the very few things that sits outside it. 2, 3, 4 former spouses could each qualify on the same record, and none of them would shrink anyone else's payment. Fear 2. They will find out, and I do not want that conversation. Social Security is not going to notify your former spouse that you applied on their record, and a divorce decree cannot sign this away. People try. There are settlement agreements out there with language that says one party waives all claims to the other's Social Security. That language does not bind the agency because these benefits are created by federal law, and a state court cannot hand out or take away something the federal government pays. Fear 3. They remarried, so I lost my chance. Also, no. Your former spouse remarrying has no effect on you here. The agency looks at your marital status, not theirs. Their new spouse can qualify at the same time you do, and both of you can be paid, and neither one reduces the other. Now let me put a fence around one thing, because I do not want anyone to hear only the good news. There is a rule called deemed filing, and it closed a door that used to be a real strategy. People born after the 1st of January in 1954 are covered by it. What it means is that when you file for one benefit, you are treated as filing for both, your own and the spousal one. You cannot take the spousal benefit at 66, while your own retirement benefit keeps growing until 70. For almost everyone reaching these ages now, that option is gone. If you read an older article that describes filing a restricted application, check the date on it, because that advice has aged out for most people. Let me change the situation, because the rules move when your former spouse has died. Now you are looking at what the agency calls a surviving divorced spouse. The 10-year marriage requirement is still there. But 3 things change, and they change in your favor. First, the age floor drops. Instead of 62, you can claim as early as 60 and as early as 50 if you meet the agency's definition of disabled. Second, the ceiling is different. A survivor benefit can be worth up to 100% of what the deceased was receiving or entitled to receive, not 50%. That is a completely different scale of money. Claim it before your full retirement age, and it is reduced, same as everything else, but the ceiling is the whole benefit, not half. Third, the remarriage rule loosens in a way that surprises people. If you remarry at 60 or later, that remarriage does not cost you the survivor benefit on your former spouse's record. If you remarry before 60, it does. But if that marriage ends, you may become eligible again. There is a reason that age 60 line exists in the law, and it is worth knowing because a wedding date a few months earlier or later can change the math for the rest of someone's life. I want to say a word here about the emotional weight of that second situation, because I have read enough comments to know it is heavy. Claiming a survivor benefit on a person you divorced can feel strange. Maybe the marriage ended badly. Maybe you have not spoken in 20 years. What I would say is this: the 10 years you put in are the reason the benefit exists at all. The law counted that decade as real, and it built a protection on top of it. Taking it is not a statement about how you feel about anyone. It is bookkeeping. There are always exceptions, and here are the ones I would flag. If you were married more than once and both marriages lasted 10 years or longer, you can qualify on more than one record. You do not collect on both at the same time. The agency pays you on the one that produces the higher benefit. If you are receiving a pension from work where you did not pay into Social Security, the rules that used to cut spousal and survivor benefits in that situation changed, and we covered that change in its own episode on this channel. If that is your situation, that episode is the one to watch next. And if you are approaching 62 while your divorce is still working its way through court, sit down with the 2 dates. Getting to 10 years, or not getting there, can be worth more than the thing people are usually arguing about at that point. So here is your self-check. 5 questions, and you can answer all 5 at your kitchen table. 1. Count from your marriage certificate to your final divorce decree. Is it 10 years or more? 2. Are you unmarried right now? 3. Are you 62 or older, or 60 if your former spouse has died? 4. Pull your own benefit estimate. Is it less than half of what you think your former spouse's benefit is at their full retirement age? 5. If your former spouse has not filed yet, has it been at least 2 years since the divorce was final? If you got a yes down that list, the next step is not a lawyer and it is not a strategist. It is a phone call to Social Security to open a claim with your marriage certificate and your divorce decree in front of you. That is what they are going to ask for. Let me tell you what that call actually looks like, because knowing takes some of the dread out of it. They are going to want proof of the marriage and proof that it ended. That means a certified copy of the marriage certificate and a certified copy of the final divorce decree, the one with the judge's signature and the date on it. If you cannot find either one, the county clerk where the marriage or the divorce was recorded can issue a new certified copy, usually for a small fee. That is a phone call and a form, not a legal battle. They will also want your former spouse's Social Security number if you have it. And if you do not have it, that is not the end of the road. Bring what you do know, which is their full name, their date of birth, their parents' names if you have them, and the places they worked. The agency has ways to locate a record from that. One more thing worth saying out loud. If the person on the other end of the line tells you something that does not match what you understood, It is completely reasonable to ask them to look again, or to call back another day and ask the same question. These are not simple rules, and getting a second reading costs you nothing but time. A word on what this video is and is not. I am walking through rules as the agency publishes them, and rules have exceptions that depend on your birth year, your work history, and your specific dates. Please check your own numbers with the Social Security Administration directly, or sit down with a qualified professional who can look at your whole picture. Nothing in this video is financial advice. If this cleared something up, tell me in the comments where you landed on that 5-question check and whether anything surprised you. I read every one of them. And if you know someone who has been carrying around the idea that claiming on a former spouse's record would take money out of that person's pocket, send this to them. That one belief keeps more people from filing than every other rule combined. Thanks for spending this time with me. I'll see you in the next episode.